Hello, everyone, and welcome back to VectoScalar Tech Talk show. In this episode, we are going to talk about a very important topic, and it is all about intellectual property. So, what is IP, and how, as a tech founder, I should be knowing about this topic? That what is the importance of intellectual property for my startup success? For that, we have an amazing speaker, Aparna Jain, with us. Welcome, Aparna, to our show.
Good evening, everyone. Thank you so much, Vikas, for bringing us on this show. Looking forward to a discussion with all of you.
Same here. For the benefit of our audience, let me introduce you to Aparna ji. Miss Aparna is co-founder of Knowledgencia Consultant. She is a practicing lawyer and did her master in law LLM in international economics law from UK. And she is also a qualified company secretary having an experience of around 15 years. She heads the legal and trademark team and is registered as a facilitator under Startup India scheme. She has been actively filing, prosecuting, litigating for protection of the intellectual property rights of the clients for branding. She is well conversant with the legal perspective, which are complementary to the entire field of compliances to be undertaken by corporate entities. She has also actively handling matters in pre-litigation, litigation advisory for startups, MNCs, large-scale industry for their corporate matters, as well as intellectual property matters. She has been diligently handling the corporate drafting FORA agreements, license agreements, assignment deeds, technology transfer, and there are many more things to go. Aparna, would you like to talk about also your company, that in addition to things that I've mentioned, what else you do under this company?
Sure. So, Knowledgencia Consultants is a partnership firm. Me and my partner, Harinder Nirvan, started this in the year 2008. So, it is specializing in all corporate practices, agreements, contracts, litigation, and it's an end to end solution for our clients. We handle the entire ambit of intellectual properties. So, that all includes trademarks, patents, copyright, design, their filing in India, prosecution, registration, as well as abroad for our clients. And also, we handle international clients, and for them, the Indian jurisdiction matters. So we are doing the enforcement, litigation, conducting raids. So it's been a
Okay.
wonderful journey. It's been now 16 years that we started this firm. So it's been every day has been different. There's no monotony in our life being co-founders and in this entrepreneurial journey. So this is how Knowledge and Share has built up. We are based in Delhi, Greater Kailash, and if anybody has any queries, they can definitely connect with us.
Sure. Thanks for sharing those insights, because now there will be a discussion about intellectual property, because there are some people who must have heard this term, that IP laws are important. They have must have heard about trademarks, but they may not know exactly. So, Aparna, would you help us understand what comes under intellectual property?
Sure. So we all have our assets. Some are tangible assets and others are intangible assets. Tangible assets are ones which you can touch. So for example, you have a car that is you can touch. It is your asset. You have a house, you have a document you can touch. Then you have all these assets which are intangible, which you cannot touch. For example, your reputation, your goodwill. All these are assets which you have built up over the years. All these things that you create with your own intellect are called intellectual property. So there are mainly
Okay.
six types of intellectual property. First of all is patents. So when you do anything new in the technology sector which is innovative, it has an industrial application, and it is novel worldwide, you can get a patent for the product or process or both. Then the second is a brand. Trademarks. All of us are using trademarks today. We go and buy branded stuff. We subscribe to branded services online as well as all other modes offline as well. So a product has a brand, a name. It could be with a tagline or a logo. All of that comes under trademark. Then we have copyright. For tech companies, copyright is extremely essential because all the softwares come under copyright per se. So the creation done by an individual could be an artist, could be a software, could be a web developer, the website pages, could be even the content that you are writing in your own diary. Every day taking notes is your own copyright. literary matters, the books that we get published, we all watch movies, whether it's Hollywood or Bollywood, the entire script is a copyright thing. The songs that we listen to, they are copyright based. So you are doing functions, you attend. All the places have a PPL license, that's called a public performance license, because you are paying royalty back to the person who sang the song for using
Okay.
it for a commercial purpose. So that's copyright. Design. So under design, whatever is the final look of a product, that is protected, not the functionality, not the mechanical features. For example, you're wearing a nice watch, a Titan Raga watch, that is under design. So the way a watch works, if it is something new, that will come for a patent. But the way it looks, the aesthetic look of a product, that is protected under design. So we have these nice new bottles of Milton, Cello every summers they introduce. So when the look is different, they will file for a design and register it, but not claim any mechanical or functional features. That is what design is. Then we have trade secret. That is not a coded law, but all of us are essentially using, and companies who have a trade secret are not registering it and keeping it secret, because all intellectual property will come in public domain after some time. But a trade secret would always remain with the company and not be open to the public. Then we have layout of semiconductor. That is the ICs that get registered because of the design. And the last IP is geographical indication. So GI is, if you have recently heard Alfonso mangoes, Kullu shawls, Himachal apples, they all have been given a status of a geographical indication. They are manufactured, produced at a specific area in India. And because of the region's climatic conditions, the community is growing, so they get a protection for the entire community. So these are what intellectual properties are.
Okay, thanks for sharing. So there are six categories, and I think uh, first four, three or four seems very important. For example, patent, brand,
Yeah.
copyright, and
Patents,
design, especially
trademark,
for a tech
copyright.
startup.
Absolutely.
Yes, yes. But why is it important to protect IP? I can just start my company, build a business, and may not bother about IP. So why is it important?
Intellectual property is extremely essential because today in the competitive market there are so many players. What is your niche? How do you make a mark? What is different that you will be serving clients as against your competitors? So that novel aspect should be your intellectual property. It is not having more people, having a better office, infrastructure. No. What is it that holds in the new company for a client, for an investor? Being a tech company, the innovations are happening every, I would say, not even 6 months, even 3 months now with the technology, the way things are changing. What is it that you can offer in a better manner is your intellectual property. So that is what you have to register to say, yes, we developed this. This is unique. This is our intellectual property. If you want any of it, you have to pay a royalty or a license to use that technology. So
Okay,
how would that formulate if you don't have an intellectual property? So it is essential. You can do a lot of business. Intellectual property is not that if you don't have IP, you can't do business. But if you have an IP, you have an edge over your competitors, over others, because you have something unique which they don't have. So that
okay.
is what intellectual property is important.
Okay, thanks for sharing it. But I would have a cross question on that aspect, that I understand about the happy case that okay, we have built the business and we have also taken the trademark. But with your vast experience into this field, you must have come across some critical cases where probably company was quite successful in their work, but because they have not protected their IP, something major happened or some major issue occurred to them. So would you like to take up any example or case study for that?
Sure, we can. So, for instance, like there are companies today who are doing a lot of like, I would just draw a parallel to once you're talking about tech companies, the way tech companies going, similarly, all of you would be aware of food companies. I would just give a simple example for you to understand the importance of brand.
Yeah.
Chios is a very well known startup started by two IITians who are tech based, technology IIT Delhi and IIT Mumbai based. They developed the brand, registered, they had so many outlets, they got investors, everything was fine. Another competitor opened ChaiOps, CHAIOPS, and was taking away their customers. They had to fight litigation. What happened? It is not that they stopped. They were changed to Chai apps, CHAIAPPS, when they went to the court. So that was one example when we see that even after building so much, getting a good name, still the brand was protected and you have to take a legal action to stop it. Otherwise, people will use your reputation, goodwill, and take away. So if we're talking about softwares and we're talking about technology, how if we just talk about the giant Infosys, the Infosys has been protecting its IP since first time. You would not like I will not have the numbers right now, but the number of patents that they are filing run in thousands for a yearly basis. That is the kind of technology that they are developing. All major companies, governments is using Infosys at some point or the other for back-end support, for their softwares, for some part of technology. And why? Because they have their own IP. They are taking a license using it. Mighty, you all these tech startups will be working with Mighty, Ministry of Information and Electronics. They are encouraging. Mighty has all these open houses and they are saying if you have a patent, we'll give you a grant. A technology startup can get money if they have an intellectual property and get to the next level. So the case studies as such, lot of them are there, but mainly for technology, copyright issues, what happens is a small time person recently what happened in one of our matters, a technology company was built up, they had a wonderful software, they did not file any IP, and their main software engineer, and they did not sign any contracts with
Okay.
the people who were working for them. So their main software engineer left, joined the competitor, launched the product before the first company could launch. They could not stop him. They are fighting, filing cases. But now you lose that leverage aspect left. The moment if you don't have an IP, you don't sign confidentiality contracts, assignment documents with your employees, people who are working. Everything in technology is all intellect based. So the resources of the company were used and used better by a competitor because he just picked up a person who was ready, gave him some more money, and took away the product of the tech company, and the company lost. They did not have they will litigate, get the person out, but they lost that opportunity. They lost that client. So these kind of things are very rampant. So in technology companies, extremely essential to see what intellectual property they are creating. And secondly, to protect it through agreements and contracts, which are binding. I don't say that you should have very strict contracts, but at the same time, there should be things written for people who are coding, who are doing the software work at the back end. So they are bound. And there's some penalty clauses so that if they leave, they don't take away the IP and the company is protected. So these things come along with an intellectual property that how are you codifying it, protecting it, recording it, and having a very strong system inbuilt in your company. Even if it's a small company, it doesn't matter. Even four people companies have been doing wonders in technology setup. How there is a growth, there's a niche area, there's an IP, and they sell and then move on. So it's
Okay.
like we have seen that. Yeah,
Okay, so probably it already answered my next question, because I was thinking that is there in any special role of IT company or tech company in IP? But as you mentioned, especially in the space of technology, everything is intellectual.
it
So
is
from writing code to even thinking a solution, everything is intellectual. So here probably there are more opportunities to file IP in the case
absolutely
of technology companies. Yeah. So
because at
uh,
time like if we compare to a manufacturing unit, they are just doing a job work.
yes,
IT companies, tech companies are creating something new. They are giving a solution, as you rightly said. So they are thinking out of the box, working for their clients or working for a problem in a different dynamic manner. So that should be protected.
sure, sure. So as you just talked about, Aparna, about the role of patents. So what is the process to file a patent? Because I've worked in large companies as well, and now while working with VectoScalar, I can see that there are new innovations that are being discussed on a daily basis, but probably we need a formal framework or understanding that at what time we need to discuss about patents, that is it patentable, what is the process to get the patent, because to a general person it seems like a long and lengthy process which is
It's
very
not
costly as
now.
well.
No, Vikas, it's not now. Things have really changed in the past five
Okay.
years, I would say. The patent process has streamlined, and two things will be extremely essential for a tech company. One is a copyright, and second is a patent. Brand will be registered only once, like whatever is the company name, that is the brand. But
Okay.
patents and copyright will keep coming. So I'll explain about both. A patent, the manner to like file it, as you rightly saying, is how to find whether it is patentable or not. So at the time when a software is being developed or a solution is being developed, if there are results which are tangible and you feel, yeah, the team says that this hasn't been done anywhere else, what we are doing, at that time the company should take a call that we should find out whether this should be patented or not, and then you should consult professionals. You can definitely consider Naljansha consultants. We'll be doing a prior art search. So when a concept is given and like a write up is given, the first step is a write up, that we will do a search that can it be patented. We will give a search opinion, and with all different patents across the world. So for patents, three things are there: novelty, inventive step, and industrial application. So the novelty has to be worldwide. So when the concept comes, you will see, and in the report, there will be patents from all across the world. And from that, the technical team can also take more inputs to make their work better. Because the kind of research they do and the kind of research a patent attorney does is absolutely different. Because we would be searching the country databases for the patents, not the market. We don't do Google searches. These would be more on the patentable databases. Then once that search report is shared with the company, the team can look into it and then give us the complete detailed like write up that this is what the work-based technology is, and then accordingly a complete specification is drafted and filed. If everything is done timely, these days our patents are coming within 18 to 20 months also. So that time period of 4, 5 years, 8 years has
Yeah.
gone long back. Things have really expedited with our startup India. And if a company tech startup is a startup also registered with DPIIT, then it could be even quicker. There are fast track processes which can be undertaken by the companies to us, and they can be filed quickly. As for a copyright, it's extremely easy. Only the copyright, like if it is a software, the language of the software is needed, the title, and the final software in a pen drive. 4 copies are needed. It's an online process which we assist with our clients. And copyright is more of a registry. It is not a substantive examination. So whatever we file, we will get a certificate within 6 to 8 months. And the moment you provide, like the companies provide, they can start saying copyright is pending, and then it gets registered, but the symbol remains the same, that is C. In patents, you can say patent pending and then patent registered after the registration. So
Okay.
these processes
Okay.
are really streamlined and things are much, much better. And if you would have seen or the last statistics, so it was a phenomenal 75,000 patents granted at December 23. So this was something which hasn't happened before. It was really good of the patent office, and they were doing
Okay.
quality work.
Great, great. Thanks for sharing the details. Before moving forward, because I have a couple of questions with things that you just shared, I have a question coming from Simple, who is asking what all should be protected. So, could you, like, especially for a tech startup, you talk about code and the patent thing, but is there anything else also, like brand name,
Uh, the brand
patent,
name,
and
first of
the
all,
copyright? Is there anything?
can
Yeah.
like the brand name of the company should be protected. The software, if it is only a software, then it will be a copyright. But if it is a complete process for a solution, then it might come under patent. And website pages,
Okay.
that is under copyright. When you develop a new website with all different pages and all the content, that entire design will be under copyright. So that is what all is protected for IT companies. Yeah.
Okay. Okay. Thanks. Thanks. Hope simple. Thanks for asking the question. Hope your question is answered. Now, Aparna, while sharing the details about the patent, you talked about DPIID. So, could
Yes.
you brief our viewers more about this? What is DPIID and how does it work?
Department of Promotion of Industrial Innovation and Trade. So DPIIT is under the Ministry of Commerce, and that is where
Okay.
under whom the Startup India movement has started. So
Okay.
if we have a new company which is not a proprietorship but either a partnership or a limited liability partnership or a registered private limited company, and they are developing something unique, they can file for a startup registration with DPIIT. And
Okay.
then the company could be Startup India, registered as a startup under Startup India, and that helps them to avail advantages which are not too much, but definitely for a patent filing. Then they don't pay the startup facilitator any professional fees for the filing. Only government fees is payable, and for trademarks also only the government fees is payable if you are a startup registered with DPIIT, and no professional
Okay.
charges because the government has put them on panel as facilitators. Like
Okay.
me, I am a
Okay.
startup facilitator for trademarks, and my partner, Mrs. Harinder Nevan, is a startup facilitator for patents. So our firm
Got it.
does a lot of startup work.
Got it. Would you like to give us a rough ballpark figure that if somebody is just asking for a review of whether it is patentable or not, how much will it cost? We may not look for exact numbers, but some rough idea.
It's very difficult, Vikasji, because we have to see how much work is involved. Because at times
Okay.
there's a lot of information which is given by the clients, at times it's not, and we only have to find from patentable or non-patentable databases. So depending upon
Okay.
the exact way, we can share it once the client shares that with us.
Got it. That makes sense. And then a similar thing would be true for filing patent, or filing patent, the
Yes,
fee remains the same.
yes, the like definitely the charges would be as per the work involved.
Okay, got it, got it. Also, I have heard these statements that once one might feel that okay, if I have got the patent in India, or if I got a something, got the IP rights in India, I'm protected all over the world. Is it the case, or there is something else to it?
There's nothing called a global IP. It's a major misnomer. Intellectual property is a territorial protection. So when you are filing a patent in India, you are registered and validly enforcing the patent only for India, not for any other country. So if you are wanting to take protection in any other country, you have to file and register. The only exception to this rule is copyright. When we do a copyright in India, that gives the protection on all other member countries of Berne Convention. So India is a signatory to a lot of international conventions for its intellectual property. So for copyright is it's a Berne Convention. The Indian registration holds good for all other member countries. So I would like to share a case here. We had a
Yeah.
copyright of India registered. It was a trademark matter which was being put on the goods, and we did not, and the trademark applications in Nepal were pending, not registered. So our client had a distributor in Nepal who was selling their goods, but there was a dispute. And despite telling them to stop using the logo, which was an artistic work of a client, and registered copyright, they continued. So we took legal action. We filed a criminal complaint, conducted a raid in Nepal on the basis of the Indian copyright registration, and all their goods were seized. Chamber of Commerce of Nepal was involved, and the matter got settled by paying penalty and damages to our client. So copyright is very powerful, and it is an underrated IP in that sense, because people feel it's because it is not mandatory. All websites have copyright all rights registered, but not, like only 10% of them would have filed for it. So if you file, you get a registration certificate that helps you in enforcing it legally. So software are under copyright. There's a lot of copying which happens. So it's always better to register your main software applications for a tech company. So it
Got
could, the same application and its registration will be valid for US also. Because tech companies normally look at India and US as the first to start up. So for patents, definitely you have to file it in US as well. Software, the Indian application and registration would be valid for US as well. So no, nothing called a global IP. Separately, it has to be done.
Got it. Thanks for clarifying that detail. Now, Aparna, you just talked about copyright, that in majority of the websites we can see that down below there is this that copyright icon is shown. So does it
Yes,
have any value if we have not actually filed for actual copyright?
it has value to say that I have created this on my own. It is my own work, and that is why it has an inherent copyright. But if there's a
Okay.
dispute, if it goes to a court of law, they would want it to be substantiated by evidence. That when did you create it? What is the document? So just a
Okay.
small example. In earlier times, there were people who used to write scripts for Bollywood, and there was not a very detailed system of putting it on emails or something. So people who used to write were sending a copy of the script by registered post to their own address and keeping that document. If ever that was used by a director or a producer without having that script writer, they could go to a court, and there have been cases where that document and evidence has been upheld, that this document was good, this was posted on this date, which was much prior to the date of launch by the competitor. So evidences like these are helpful. Today's era, we have emails, we have communication to say that this is, I have given this idea to you, or it's a work for hire, I paid you for this, you don't enjoy the intellectual property in it, all this, of course. So it is something
That
very
was an
essential.
that was an interesting and very grassroots innovation example, that how you can protect your IP and copyrights
Actually,
even when there was no formal system to it. So by
it
sending
wasn't, and people did
registered
it that
post and
way.
keeping it sealed.
Yes, yes. Some people do it now, also people who are artists and all, and novels who are writing, they would probably do this. They would, like, till the time it gets published or something, they would just keep a copy like this so that it's protected. So you never know. Three Idiots, everybody
That's it.
knows what happened in the Three Idiots story. 5 point someone, Chetan Bhagat, and they had a dispute. So all this is now, it's very extremely essential. There's a valuation of intellectual property. I would just like to take for tech companies why it is more also important. Most of the tech companies are looking at investors. So what is the valuation of a company? How will you value? The valuation comes with intellectual property. When you have an IP, that is what is valued, and an investor will come and invest, saying that yes, this company is doing something different. We'll invest, and it will be a growth for us. So at valuation terms, also intellectual property is extremely essential.
Got it. Got it. My next question would be that, as you just mentioned, that it might take up to 6 to 8 months of getting the copyright for certain piece of code or things that have been done. But in our industry, as I see, majority of the things are like that, that you are continuously building them. It's not reaching a final stage ever. So when, for example, if say we are building a software, it is ever evolving, bugs are getting fixed and things are being developed. So at what time we can say that, okay, now we are filing the copyright, and to this piece we need the copyright for?
At a slightly matured level, at a like removing bugs and slight changes, your copyright will still remain the same. So slight
Okay.
changes are fine, but majorly it should be solving the issue. It should be complete in itself. Slight modifications will always happen that will not give another person a copyright. So at a matured level, at a time when you feel yes, it is solving all the problems and slight issues and deficiencies are there, that can be done. That time you should file it.
Okay. Okay. My next question would be that, for example, if somebody is just bootstrapping their tech startup, so right, the focus would be more on getting the business, hiring engineers, building the product. So at what stage they should bring the
At the same stage.
consultants like you, yeah,
I would say at
on
the
board?
same stage. At the same stage. Like we have been facilitating and helping so many startups from the stage when they're building what kind of a company they want to have. So that hand holding happens at a correct stage to identify. So, like with consultants like us, you can also assist in identifying what is intellectual property in your company. Then, what is it that you need to protect? And if you have, like we should say, have that hand holding from an initial stage. It is not that after we do business of 1 year, or of 1 crore, then we'll look at intellectual property. No, it has to go from the foundation. Only then you will reap the benefits. When we talk
Okay,
about
so
Silicon
it has to
Valley,
start
forget.
from the beginning itself.
Yes, absolutely.
Okay, that makes more sense. Now, talking about the brand, because it seems like an easy thing that once we have found a name, it is protected. But as you mentioned, and I think there have been many cases where finding the word itself is quite tricky. That what should you
Yes,
keep the name of the thing, and that's why probably we see very different kind of words for companies like Uber, Ola, which are not having
yes.
any specific meaning. So if
That
someone
is the
is
best
just,
thing.
yeah.
So if you
So
don't have a
how
meaning, it's unique.
yeah. Okay, okay. So, what should be done? Like, if somebody is just thinking about a name for a company, typically in our case, I have seen people just finding a .com, but probably finding a .com is just very small piece. It's not
Yes, it's a
getting the
small piece.
intellectual property right. Right.
What we would suggest is that definitely a Google domain name helps, because it creates a usage that yes, it was unique. That's why I got a domain name. Checking it
Okay.
in the trademark specific class and filing for it. Even if your company incorporation is taking long, the founders should finalize their brand and file a trademark in their personal names if required, and later on transfer it to the company, because the company incorporation would take easily 4 to 6 weeks when you have a company to be registered. And that type also, that level also, MCA, the Ministry of Corporate Affairs, will check that whether the name of the company is not somebody's trademark. So I would just like to tell you, companies like Hitachi are well known trademarks, brands. Nobody can have the word Hitachi even in their corporate name or in a trademark. It is well known across classes, across the globe, because of their registrations, because of the magnitude and magnanimity of the brand. So if you have a brand, you'll be filing it for registration of a company also. File for a trademark so that it is clear. And when you are giving it for registration, the name shortlisting happens at the first instance. That you give 3 names and one gets shortlisted. At that instant, only file for a trademark so that you are doubly protected. And at times, the trademark and company name is not same. Like as you rightly said, Uber and Ola is not the company name. So I would, Vikas, do you know what is the company name for Sony? Any?
Sony.
Yeah,
No, I assume it was. It must have been Sony itself.
no, not at all. So it is Zai Huai Technologies. It's a complete name. So people don't even know who owns Sony. The brand became bigger than the company. So that is what
Yeah,
happens with a brand. So that was something
yeah.
unique. And way back, there was a matter in which Sony, Sony, filed a case in a place called Pinjore near in Himachal. There was a company, there's a shop, small shop called Sony Jewelers, Sony, and they said you cannot use it for jewelers. They said it's my surname, because in India Sony is a surname also, Soni.
Yes,
So the
yes.
court directed them that change from Y to I, because Sony is such a well-known mark. You cannot even have a jewelry shop with Sony jewelers. So that is the power of a brand if you can encash. Havells is a brand, well-known brand. So today one cannot even make clothes or a software with Havells name, though they are not into it. They are only into electronics, but they have created a well-known brand. You do not have shops or clothes or boots or anything else with Havells, because that becomes a well-known brand. So you cannot copy it for any service or goods. That is what the brand can do for you.
Okay,
Yeah.
that's interesting to know, and that was interesting. I think I just knew a Indian example, well-known example of Paytm, where the company name was 197 Communication, but it was
Yes.
quite famous under the name of brand name of Paytm.
Yes. And then PayPal and Paytm have been litigating. So
Oh, I
Paytm
did
and
not know
PayPal
that.
have a similar combination, the dark blue and the light blue. PayPal has
Okay,
been in US much before Paytm started. Like
yeah,
PayPal has been for card things. So they opposed
yes,
Paytm application and said that you cannot have this trademark registered. Finally, they settled the matter, but it had been a good long fight because the color combination was same. they said PayPal से ही आपने you have copied Paytm from PayPal, and they said no, Paytm is different, PayPal is different. So
Oh,
these things
I
are
can
kind of,
understand. Yeah, being into the industry for quite a long, I can see that how the things might sound similar, but still somebody want to protect their right. But I think it
yes.
was great sharing with you, Aparna. I think we have a lot of other questions with us, but in the paucity of time, we may not be able to ask all the questions. And
So
for the benefit of our audience, if you really want to connect with Miss Aparna, you can have the LinkedIn. You can note down the LinkedIn down below and connect with her. And I'm sure you must have also be some idea, some brand name in your mind which can turn into patent or an innovation or something else. So definitely do at least explore that part, because when we are talking about taking India at the global stage, and when we are talking about that who are the most innovative countries, I think patents and innovations, these kind of things are actually the benchmarks of deciding that who is innovating the most, right? So if we want to
yes,
take the brand value of India to the next level, we need to have more patents and such kind of things, so that we can build brand India, right?
true, absolutely. So it,
So any
yes,
last message, Aparna, for the audience? And I understand you talked about that on the personal front, you are a foodie, and you go into traveling. So is there any story before we close the session? Is there any story where while traveling you come across anything related to brand and you
yes,
got?
while traveling, we come across a lot of imitated goods which are counterfeits. For example, small Vaselines, wastelands. Then we go in Rajasthan, you get all counterfeited Bisleri bottles. So they will have
Yes.
Bisleri, they will have Biseri, Lel, and all of them look same. And the rampantness which they grow is humongous. So yes, with a brand, these challenges come, and then it's interesting to see how a brand has evaporated to a grassroots level that people are just buying anything because it looks like Bisleri. So
Yeah.
Bisleri has created that kind of a brand. So these things are interesting, and I would just like to thank Vikas for this wonderful session. And anybody who would like to connect with us, our website is www.knowledgeancia.com, and you can connect with us. Our details are there, and the LinkedIn profile is right here. Thank you so much.
Thanks again. Yeah, thanks again, and thanks to the audience for such a wonderful audience in the past and in current session as well. In case you have any further query, you can type in the comment box below, and we'll make sure that that question get answered even later time. And in case you want to have another kind of session covered in our future program, do again type in the comment box below, and we'll make sure that in our future session we'll find a speaker, another guest tech speaker who can talk about that particular topic. With that, keep learning, keep growing, and keep filing patents, keep growing the intellectual property of the country. Thanks, Aparna. Thanks for being on the show, and thanks to the audience. Have a nice day. Bye bye.
Thank you. Bye. Thank you.